So, Chapter 9 is the last chapter in Unit 3. It's about legal writing. Probably, as I said, the second most common thing you do as a paralegal. You're going to draft multiple types of documents, and we'll spend some time in different classes talking about and drafting these documents. This is more just a focus on those documents that we'll cover in legal writing, but keep in mind you'll be drafting different documents in every course. Okay, usually in legal writing, the course you are putting into a understandable format what you have found in your research. So the first, and that title's cut off, but the first thing is making sure you understand what your assignment is. We've already discussed about with regard to research, you've got to understand what you're being asked to find out, and that applies to the writing piece as well. You need to know what kind of document is going to be the ultimate product of this research that you've done, and who that document is going to go to. So you need to make sure that you are clear with regard to the assignment and you know what is expected of you. You also need to make sure you understand the time constraints that are being placed on this assignment. You know, sometimes you might have 2 weeks or a month. Sometimes you might have 2 hours. So you need to make sure you understand what your time constraints are. Be flexible, because sometimes things will come along. Even if you have a 2-week period to work on a document, you're going to be doing other work in between that's going to get assigned to you. So you have to be flexible and be able to adapt to the changing circumstances. Always budget extra time, because just things happen. So you have to be able to react and reprioritize. Writing in the law usually divided into 2 areas. You've got your documents that call for an objective analysis, looking at both sides of the problem, being neutral, being objective in what you present after you do your research. This is called predictive writing. You're trying to determine what a court is going to do. And then you have the persuasive documents. That's where you are trying to persuade someone on behalf of our client. You're advocating for your client. Usually those documents that require persuasive writing are a little bit easier for us to draft, because we, being legal professionals, that comes natural to us to want to advocate on behalf of our client. And so it's the objective documents that tend to be the most difficult for us to look at something objectively without a bent toward our client, because sometimes you must do that in order to see the weaknesses in your case, to see is this something that we want to move forward with? Is it something we want to try to settle? All of those things require an objective analysis. Law is a communication intensive driven profession. We are constantly communicating orally and written. to our clients, to opposing counsel, to our supervising attorney. So it's very important that you are a good writer. It's it's going to be your bread and butter. Okay. Format. Make sure that when you're drafting documents that you are formatting the document the way that, if it's something to your supervising attorney, the way they want it. If it's going to the court, that you have researched the formatting rules for that court and that it is being formatted properly. Your supervising attorney may have specific formats and templates for certain types of documents, so you need to make sure you're aware of that. You always want to write with your reader in mind, okay? You want to write at their level of understanding. You want to write to their to the way that they best interpret the information. So you need to know what's the reader's needs, what is the reader's level of legal knowledge, their understanding. You need to know those things in order to effectively communicate with them. Some tools. You need to accurately use legal terminology. You need to know the specific rules about how to cite the sources that you have found in your research. Clear and organized. And you have to, depending on the document, have some specific organization to the document. You always want to outline your material, where you're going with the information you found in your research, and how you want to communicate that to the ultimate reader. Organization is essential to that, and you want to even be thinking about that framework even before you get your research and before you are writing. Don't wait until you're actually putting pen to paper or fingers to the keyboard. Figure out what is the most logical organization for your information. Organize it logically. Divide it into digestible blocks of information, short paragraphs. Address similar topics together, address elements of a statute or the case in order. Know what the purpose of each paragraph is, what you're trying to convey to the reader. Use headings if at all possible. It helps the reader digest the information. Write effective sentences. We spend a good bit of time in research and writing, both 1 and 2, focusing on our grammatical skills. There's a grammar quiz every week, and in addition to the content quizzes on the textbook, but there's also these grammatical quizzes trying to help you identify your writing weaknesses and or speaking weaknesses and how to improve them. Things like using active voice instead of passive voice, use plain English, not being overly reliant on quotes, especially when you're talking about court cases, using gender neutral substitutes or gender neutral terms. You want to use concise language. Here's a chart that's in your text. Things that we don't think about, but that can be said much more concisely. In the event that 4 words can be replaced by 2 letters, 1 word, if. That's what in the event that. It may be argued that, arguably, for the purpose of, for. Those are ways to be more concise with your writing. Always make sure that you have built-in time to edit and proofread your documents. We all tend to be procrastinators, and so we push it until it's absolutely due, and then you don't have that time that you need in order to properly edit and proofread. You have to have time to walk away and come back with a fresh set of eyes. Don't overly rely on spell checkers, but yet still use them. I get documents where I think, oh my gosh, they did not even run spell check on this. Go through several drafts. You're never going to, or you should never, submit to your supervising attorney or file with a court something that you've only drafted. All you really have is your basic initial rough draft. Look for feedback from others, asking them to give you notes on ways to improve. In order to get a polished product, you have to put in the time. Editing. Edit from a printed copy. It's difficult to actually accurately proofread from the screen. Always double check names, dates, numbers to ensure that they are accurate. Edit content first and then go back and look for stylistic ways you can improve your document and grammatical and spelling issues. Always, as I've already said, make sure you understand the purpose of the assignment, what type of document you're ultimately being asked to produce, who's going to be your reader, your audience, what time and money constraints do you have on this assignment, what type of format you're being asked. Always choose the right time and place for writing. Don't try to write when there's 15 other things going on around you. Don't procrastinate. That's going to affect your ability to edit and proofread. If you don't know where to start or you're having trouble, start with the part that you feel the most confident about with regard to that document. If that means starting in the middle or the end, that's fine. Don't let your first draft be your final draft. These are just some tools to help you. Pleadings, discovery, and motions. Those are some documents you're going to learn to draft in courses throughout the program. Probably the two courses where you will use these the most are going to be civil litigation and family law with Miss Murray. But these are documents that get submitted to the court, and they are written persuasively, trying to persuade the court to find in your client's favor. Critical to know the rules of the court in the specific format that they want a particular document in. The next category is legal correspondence, letters. we will spend some time on specific formatting for letters. If you don't remember that, I know that, I don't think that schools, elementary schools, spend as much time on this as they did when I was in school. We had a unit on it, I think, almost every year. But the specific format for letters we will talk about, but that includes your date, your address block, excuse me, your address block, who it's going to, how it's being delivered, what this letter is about, your salutation, err on the side of formality. Don't be too informal, especially if you're writing to someone, your client or opposing counsel. You're better off to be more formal than less. Then you have the body of your letter, the closing, the signature. You need to include your status, your title. We will talk, as I said, in research and writing about the specific formats for letters, because we attorneys do a lot of letter writing. And if it's not traditional letter writing, it's emails that are in the form of a letter, following the same writing conventions as when you are writing a traditional letter. Depending on the textbook that you read or the legal experts that you read, they will, excuse me, break down the types of letters. They might say there's 3 types or 4 or 5. Informative letters, those are letters where you're conveying information to a party, to another party. Clients, opposing counsel, witnesses, maybe letting people know when a particular deposition has been scheduled, or asking for particular information. Confirmation letters, still a type really of an informative letter. I would group them together. Summarizing conversations that we have with different individuals, and putting that in a formal letter so that we can put it, not only send it out to the person that we had the conversation with, but also as a documentation for our file. Opinion letter, we are giving information to the client about the status of their legal rights. So these are letters that only the attorney can sign, but paralegals certainly can draft them. Same goes for demand letters. We are demanding a party take some particular action. That also must be signed by an attorney, but certainly can be drafted by the paralegal. The legal memorandum. This is the document that's probably the most common behind letters that you will be drafting. Attorney's going to give you a research project, ask you to go do this research, and then draft a legal memo where you are going to explain what you found in your research, do an analysis, and make a prediction about what you believe the court is going to do based on the research that you have conducted. So this is traditional format for a legal memo. You have the heading with the date, the to, the from, and what it's about. We call the issue in a legal memo, some will call it the question presented here. There are 2 questions presented. So what are the issues basically that you have been presented with based on the client's information, okay? And they are drafted in light of the law that you have found in your research, okay? From those, you'll get a brief answer, just a short answer to those legal questions. You're going to have a statement of the facts, giving a factual background to what happened in this particular case. Only those facts that are relevant and have a bearing on the outcome of the case. Remain objective in your facts, and be organized, whether that's chronologically or topically. Just have some organization to those facts. Then you're going to have a discussion. This is the detailed analysis of the law that you found and how it applies to the facts of the client's case. Once again, you want to follow organization. You want to be organized. This discussion is going to have an element of IRAC to it, where we're going to identify the issue, explain what the law is, apply the law to the facts, and come up with a conclusion. And then an ultimate conclusion of, what we think the court is going to do in this particular situation. We may have to, talk about what additional information we need, or is there, is there missing information? Are there things, more research that we need to do? Coming up with a way to help your supervising attorney with the next step in this particular case. So this is a short overview of legal writing. As I said, we will spend a lot more time on this in the research and writing courses, but this is a basic introduction. So next we will move into Unit 4.